All right, I'd like to go over the real estate purchase contract package. So the package has disclosures and the contract. So the first thing, the first 2 pages is the agency disclosure. So that's the agency responsibilities, and that talks about the seller's agent, the buyer's agent, and if you're an agent representing both the buyer and seller, what our duties are. At the bottom line here, we have a duty to be honest, fair dealing, and good faith. It also lists out some of the things what you can do and not do if you're representing both parties. The next page is actually the civil code. This is California legislators wrote this, and which requires us to provide the agency disclosure and also the confirmation of who's representing who. All right, so the next page 3 of the package is a purchase contract and the escrow instructions. Just to be clear here, once the buyer and seller get an agreement, there's the third party, the escrow company. This RPA, see it's RPA, is the instructions that we're going to send to escrow, because the escrow company takes instructions from the buyers and the sellers, and they do what they do, and they're using the purchase contract, the RPA, as their instructions. So all right, so let's go ahead and dive into the RPA, what the basics of this is. So paragraph 1, this is just basically an offer from John and Jane Doe for this property here to the seller. All right, this is an agency confirmation. This is actually confirming who's representing who. So in this particular case, I just marked that Glenn was, Compass was representing, we should let both parties, we'd mark a X here, X right there, since they're representing both. This could be Remax here, that could be Coldwell Bank or anything else there, then they would just, each company would be representing the individual person. Let's dive down into the terms. So what's nice about our contract now, it is 17 pages. If we look down here, 1 is 17, so 17 pages long. All the blanks are pretty much on page 1, page 2, and page 3. There's no, and page 4. So those are the blanks in the contract, and then the rest of the contract actually explains everything that is in the front page of the contract in these boxes here. So the only exception to that is the arbitration disputes and the liquidated damages, and we'll get to that. But everything else that's filled in is on the first couple pages. So let's jump in right here. So the rate start off with paragraph 3. You have the purchase price. Purchase price, close of escrow, how many days it's going to take to close escrow, the initial deposit, loan amount. Over here it also goes over what type of financing that's there. Down here is the property occupancy type, which if it's your primary house that you're going to live in, secondary home like a vacation home, or if it's an investment property. It sort of spells this out right here. Next page, we jump into the seller payment and covered buyer expenses and costs. That's what this section right here is, G. If there's any additional credit, so the seller's crediting the buyer $10,000 for closing costs, that would show up right here. These days, the way compensation works, the seller's payment to compensate buyer's broker is spelled out here. And then verification of the down payment and deposit. The seller wants to make sure that the buyer actually has the money in the bank, and so we ask for the VOD, verification of money and deposits. This right here explains what the as far as the loan verification application, if the buyer's providing a pre-qualification letter, pre-approval letter, or fully underwritten approval letter. So if I'm representing you as a seller, I'm going to be calling the lender on the buyer side and asking them those questions. And so when we present the offer to you, Mr. and Mrs. Seller, we will know, how strong we feel that lender is if I'm working with you as a buyer, you can rest assured that you're going to be fully underwritten or pre-approved and fully underwritten. It depends, one of the two, depending on what strategy we have and where we're at in the loan process. Final verification of condition of the property. 5 days before the close of escrow, the buyers have an opportunity to walk through the property, make sure the property is in the same condition it was the day that made the offer. This is the assignment request. This is if the buyer wants to assign the contract to somebody else, because the contract is not assignable on, without making the request. All right. This next part right here, this is an important part. This is the contingencies. So it's contingencies right there. There's 3 basic contingencies. You have the loan, appraisal, and inspection. Then also the review of the other documents is really important too, but let's just go through this quickly. The loan is your financing. If there's no loan contingencies, we'd be marking the box over here. If there's no appraisal contingency, we'd be marking the box there. If there isn't a property inspection, we'd actually mark this box down right here. This right here is CR-B. This is the saying that there's a contingency removal form. So we'll look at that later, which actually is an additional form. But this right here, it says the number of days it takes to remove those contingencies. Some of the other really important contingencies is fire insurance. The seller disclosure. Most times the sellers are providing the disclosures up front, so that's usually handled and done. They also provide the preliminary title report. If you want information on that, you can watch an additional video. Common interest disclosures, if it's a condo, things of that sort. Review leased items, if typically this review leased items comes in the form of solar. So if there's no solar, or if the solar's owned, there won't be the leased items, and they'll disclose that up front. Sometimes buyers have a property they have to sell, and that's what this particular addendum is. It's called the COP, and that's if they have a property to sell, will be filled out and attached. So when you mark this box right here, it actually attaches that addendum to the contract. Time and possession. Many times the contract is standard. If the seller's not living in it, the buyers will take possession as soon as we close escrow. And by standard, it's once we're notified of recordation, which is usually anywhere from 11 a.m. to 3 p.m., or you can mark additional times. This right here is the seller occupied or vacant unit. So in other words, if the seller is occupying the property and they want to stay in the property for a few days after the close of escrow, up to 29 days, we add an additional form. So if you mark this box right here, the SIP would be included, the seller in possession, and that's for less than 29 days. If it's more than 29 days, 30 days and more, it's actually like a regular lease, and that's why we use the actual residential lease form. Staying in the property could also be limited by the number of days that the buyer's lender will allow, which is actually the buyer, if they're going to be owner occupied, they're going to be in the property within 60 days typically. This right here talks about if it's tenant occupied. So depending on the circumstances of the property, that could be very important, especially if there's rent control and things of that sort that make it a little bit more complicated to take possession of the property. Going right down here, documents and fees and compliance. Seller delivery of documents. Again, many times that's done up front these days, found in Disclosure IO. Time and pay fees for HOA. Again, most sellers, if they're on the ball, they're going to actually get these HOA docs ordered before they put their house on the property, just because it takes sometimes several weeks to actually get that. Installing the smoke detectors and things of the sort. This is actually some statutory requirements, that there's smoke detectors and CO detectors. It speaks to that. And evidence of representative authority. So if you're a trust or holding title as a trust and things of that sort, or if you're a power of attorney, providing evidence that that's the case needs to be done in a certain time frame. So moving along right down here to the next page, items included and excluded in the sale. This is an important paragraph that it's been greatly expanded over the renditions of this contract. In a real estate transaction, many times there's what we call fixtures and personal property. Personal properties is usually not attached. It can be like furniture, things are sitting around. Fixtures are attached. And so because sometimes you have TVs that are attached, it's confused with, like, is the TV mount a fixture, or is it personal property, or is it TV, and things of that sort. So to clarify that, so there's no misunderstanding, they've included all these different items here. Like if you have a video doorbell, that box should be changed. If you have security cameras, bathroom mirrors, I mean, they're hanging up there. Many times they're attached. So this is an important paragraph to attach. Many times it's put in the MLS, what's included or not included, but regardless of what you put in the MLS, the RPA, real estate purchase contract, this is what really matters. Allocation of cost. This is going to spell out who's paying what for specific types of cost. So there's some things typical and traditional in different areas, but the natural hazard disclosure, typically the seller pays that. And then when it comes to wildfire disclosures, again, the seller typically pays for that. And if there's any other types of disclosure reports that the buyer wants to request the buyer or seller to pay, they should mark it down here. Smoke alarms and detectors, again, statutorily it's supposed to be there before the close of escrow, and many times the seller pays it. These next two items, we call them point of sale, POSs, that are required. And government requires, city jurisdictions many times require that there are certain reports and inspections, like and also if there's any type of corrective work. One of the more common one is the sewer lateral inspection. The city of Oakland also has a sidewalk inspection. Walnut Creek has some environmental air conditioning or environmental requirements and reporting. Escrow fee, typically the buyer pays their escrow fee. Title insurance, buyer's owner's title insurance and buyer's lender title insurance. Many times the buyer pays that, but it is negotiable. All these fees are negotiable. They put down here buyer's lender title insurance as a buyer always paying, not willing to change that. But if you were getting a credit from the seller at the top right here, if buyer got a credit for closing costs, they could pay all those things regardless of what's marked down here. Transfer tax, that's a whole other topic here. The county transfer tax is typically paid by the seller in most areas. It's typically $1.10 per thousand. So for 100,000, and you just multiply $1.10 times 100, and so it's like $110. 100,000, it's $100. The city transfer tax, that's negotiable. A lot of places, let's say if it's $7 per thousand, which is way more than a county transfer tax, many times the city transfer tax will be split 50-50. HOA transfer fee, many times, or the doc fee, the seller will pay for that. The certification fee and things of this, the HOA transfer fees, this is all sort of negotiable. If there's certain private transfer fees, that's again negotiable. Home warranty, this is negotiable buyer or seller, and if you want a home warranty, you can choose, and then also pick what company that you'd actually ask them to use. Moving right along down here, property addendum and advisory. So depending on the type of property, if it's tenant occupied, if it's a probate, a manufactured home, TIC, tenants in common, which they have in San Francisco and Berkeley and different places, is more common. Stock cooperative, mixed-use purchase. These are specific addendums that are these forms right here that were disclose additional information to the buyers regarding these type of properties. So if the property is one of those, then those boxes will be checked, and that additional information will be provided to the buyer. Again, we want buyers to be informed. All right, additional addendums like backup addendums, septic addendums, if you have a well, things of that sort. These are if it's a short sale, if it's a probate, court confirmation is required. This is what all these addendums are for. Buyer and seller advisories. Again, we have advisories, we have disclosures, and we have contracts. So these are just as the standard of our purchase contract package. So this is the purchase contract we call the RPA. In the package that our program kicks out, these are the standard advisories that are included in that package, that buyer's investigation advisory, wire fraud, fair housing, and California Consumer Privacy Act. If it's in a high fire area, if it's a trust or REO bank-owned property or probate, we'll mark these particular properties, include those advisories also, and that's just information for buyers so they can make informed decisions. All right, so paragraph 5 and on, there's basically nothing to fill out here. It's just all a bunch of information, good information, and what this information is, it's referenced. If we go back to the first 3 pages right here, you can see here on the reference paragraph number. These paragraphs right here are all these paragraphs that back down here that explain those particular items. So when I talked about, let's say if you go here and you want to talk about, let's say the earnest money deposit. So we go to right here, EMD. So initial deposit, they put 3% down. Let's go read paragraph 5A1. That's going to explain more in detail about the earnest money deposit. So you go back down here, 5A1. There's 10. I sort of blew by that. Okay. 5A1. Here it is right here. Initial deposit. So here's some more information about the initial deposit. So all these paragraphs are referenced in, this is basically, this paragraph is paragraph 3, which you got paragraph 3 right here, which has the terms and purchase and allocation of costs. And then the paragraphs listed down here are the further detail. So I've actually marked through this. I could actually go through each one of these and explain in a little bit more detail, but it's I've highlighted some of the information here for you to check out and read. So I've included the PDF. So maybe I'll just go quickly through this, and but we're going to try to, if you have additional information, you can read further into it. So, for the initial deposit, they talk about that. Additional financing terms, closing in possession, they go in further detail. A lot of this stuff doesn't come up unless there's an issue or a question. Then we can always go back to these paragraphs, and it actually is a great roadmap, and it is the binding contract between the buyers and sellers that explain how to handle things. Contingencies and removal of contingencies. This is essential. When you have the contingencies, the loan, the appraisal, inspection, and things of sort, this explains how they get removed and what gets done about that. Insurance, it talks a little bit about that. Title, holding title. Condominiums, removal and waiver of contingencies with an offer. We're just making the recommendation. We actually have a disclosure. If they come in with no contingencies, we have a buyer sign a disclosure and advisory regarding that. Removal of contingency or cancellation. There's a whole paragraph on what we talked about, fixtures and personal property. Here's just an additional paragraph that talks about the individual type of things that can occur. Allocation of costs, government requirements. Remember we talked about the POS, point of sale requirements. It talks about that. Paragraph 11 is statutory and other disclosures. This is stuff that it just is statutory means it's required by law. And other disclosures are sometimes disclosures and advisories that we feel that are useful and helpful, and that that they put together the information so buyers can make an informed decision. So we're going to go through and explain all those different items. Just as a general, really important rule here, known sellers are required to disclose known material facts. This is so essential, and this is why there's so many disclosures, because we don't want buyers to be surprised. Buyers have the responsibility in investigating their property, and they're going to get disclosures, inspections, reports many times from the seller, but at the end of the day, they need to investigate the property and matters affecting the property. They need to do their due diligence. They have a responsibility to get involved in doing that, and just can't expect just to hope and wish. You got to spend the time digging through the reports. Time periods. This is just the time periods and contingency removal and cancellation rights. This paragraph right here explains, like, if a buyer doesn't remove the contingencies, what happens, and what's the seller's right to cancel. If the seller doesn't perform, what's the buyer's right to cancel. Everything is spelled out in here and how it's done. That's why this is a good roadmap, and this is why all these additional pages are really important. What happens if the buyer doesn't close escrow? The seller can't just say, well, you didn't close yesterday, so we're canceling the contract. The seller has to make a demand for the close of escrow. They have time to actually perform and get it done. So there's a paragraph that explains all this, and these paragraphs and the terms in the paragraph are part of the purchase contract and the terms of the agreement between the buyer and seller. So what happens if you cancel the contract on the deposits, repairs, that walkthrough final verification before the close of escrow? There's a little paragraph here that talks about that. Proration of taxes and other items. Brokers or compensation. It talks about that. Escrow instructions. Again, I mentioned to you that this is the purchase contract and joint escrow instructions, and this is just explaining what that's about. Some more about the broker compensation. Selection of services. Multiple listing services. Information will be reported to the MLS fees. This is an interesting little clause, attorney fees clause. If there's a dispute between the buyer and sellers, there is a prevailing attorney fees clause. The loser pays, but just FYI, you better. Let's get rid of this right here. You better know what it says on. Oops, I did it again. What you have to know what's on paragraph 27A. What that paragraph basically says, you're not entitled to attorney fees unless you go to mediation first. So that's if you go to 27, that's what this paragraph right here says. If a party refuses to mediate before a dispute starts, that party shall not be entitled to attorney's fees. So again, first step in any dispute is, call your agent and whatnot, and then, if there's mediation services and things of that sort required, it talks about that. Assignment of the contract. This is actually an important paragraph, paragraph number 5, definition and instructions. When you want to, like, how many, what's the close of escrow? What does that mean? When you're counting days, what does that mean? So it's like 3 days after the acceptance, 4 days before, all that stuff. What does delivered mean? These are all the stuff that actually specifically says, explains the terms in there that are many times we go back and reference to make sure we know exactly what's going on. This paragraph, these 2 paragraphs here are the only other 2 pages in the purchase contract except for the first 3 that the blanks are to be filled or not. If you choose to have liquidated damages, you initial here. If not, you don't initial. Same thing with arbitration disputes. Again, you need to initial that, and both parties need to agree on that. Additional terms for appraisal act. That's just good reading information. Time is of the essence. That just means that the dates in the contract are actually actionable dates. There's not, when they say 3 days to remove the contingencies, they don't mean 3 or 4 or 5. They mean 3. So that's, you have to have this term in there. Time is of the essence. This is the offer, how good the offer is good for. That's all spelled out here. Buyer's signatures. And if a seller wants to accept the offer, they can just sign down here. If there's actually a counteroffer, they would actually mark right here. Or if there's if they're putting them in a backup position, this is actually for a regular counteroffer or for a multiple counteroffer. But these boxes would be checked depending on what the circumstances are. Boom, right there. Seller's entity, again, if you're a trust or things of that sort, or have power of attorney, those boxes would be checked accordingly. So that's the essence of the real estate purchase contract. I hope that was helpful. Got any questions, of course, reach out and talk to me, and we'll look forward to talking soon. It's Glen Allen, the Glen Allen Real Estate Team with Compass Realty.